Thank you. I guess the only thing worse than being scheduled right before the cocktail party would be scheduled during the cocktail party. And after a day of hearing about how you and your policyholders are going to get breached if they haven't already, and you and your policyholders are going to get sued, you all probably need a drink. But before you start drinking, you should wait because it gets worse. After you get breached and while you're getting sued, you also might get investigated by either federal or state authorities. And so that's what we're going to spend our time talking about before we all start drinking. I just to set the table, I joined Steptoe this year after 15 years at DOJ, and the last 4 of those years I was a Deputy Assistant AG in the Criminal Division, and I oversaw the Computer Crime and IP section. And during that time, I helped supervise the criminal investigations of some of the breaches that we've been hearing about today. My primary concern in dealing with companies at that time was making sure that they were willing to engage with law enforcement. But it also gave me a front row seat at watching them respond to breaches and seeing those that did it well and those that did it less well. And now that I'm in private practice, I'm trying to apply those lessons and get companies to take steps both before and after they get breached to minimize their risk. And one of the greatest concerns that companies express to me on a regular basis is that after they get breached, besides getting sued, that they're going to become victims, they view themselves as victims of investigations as well, and that they're going to be targeted by the FTC or by state AGs when they themselves have just become the victims of a breach. And among state authorities, there are no more active state AG's offices in this space than the ones in California, Florida, and Vermont. And today we have an invaluable opportunity to hear from the people in those offices who are most responsible for overseeing their data breach investigation and response programs. And it's a privilege for all of us to be able to hear from the people in the front lines of these investigations for these states. I'm going to save them the trouble of saying this 100 times. The opinions they're offering here today are their own. Based on their own experiences, and they're not purporting to speak for their offices or to set policy for their offices. So they probably will still say that at 99 times, but now they don't have to say it 100 times. As we get going, I'll let them each introduce themselves. Ryan Krieger is, I don't know if the picture's still up on the iPad, but Ryan Krieger is on the phone, and he'll be jumping in frequently as well. So why don't we start, and as I said, as they get talking, I'll let them introduce themselves. Why don't we start with where I left off, which is the concern that companies express about how, as breach victims, they're being victimized again and they're being blamed for the breaches. That is by far the most frequent complaint I hear from companies, usually directed at the FTC, but sometimes at state AGs as well. So why don't we start with Adam. Adam, talk to us about that concern. Do you hear the same concern, and how would you respond to it?
We do hear that concern, and I've heard from many quarters, including today, the refrain, it's not a question of if, it's when. As a state regulator, I kind of refuse to accept that. I do concede that there are some kinds of data breaches, such as the Chinese hackers that we've been hearing about, that may not be inevitable, that may be very hard to protect against. Certainly zero-day exploits, it's hard to prevent. But in California, like many other states, we have reasonable safeguard law that says you have to take reasonable precautions to protect your data. And in California, I don't think we're going after every single company that has a data breach. We don't have the resources to do that. This unit that I'm in charge of has only been around for 1 year. So right now we're kind of focusing on the low-hanging fruit, the people that don't have processes or procedures in place. The kind of people, I guess, from being at this conference that don't have insurance. From what I've heard, your best customers are the people that have already been breached. So it's not, I think, fair to say that if you report something to the government, you're going to get dinged by the government. I think the better argument is that if you do not report to the government and we find out about it, then you will get dinged.
I think that's true. I think we do hear that from companies. We've been victimized, but we also hear from consumers. And consumers report to us that they feel victimized. So we feel, at one point, we're talking to the company and saying, why are we in the middle of this investigation? Where at the same time, the consumer is saying, it's my social security number. What are you going to do to protect us? So we walk a fine line between both of those issues. And oftentimes for companies that feel that they are victimized, many times after we have walked through the breach issues with them, they start to realize what role we're playing. And I think information is really helpful.
And I have a really good, very recent anecdote to share. Yesterday I got a call from a big company I'm not going to name, and it was basically a courtesy call saying that they had a minor data breach. I'm not going to describe it. That didn't even involve enough people. In California, it's 500. That would have even triggered a notification. But because they've been involved in other things and they know that we're interested, I got a call from people never met, never talked to, and they said, just want to give you a heads up in case you hear something. Here we are. This is what happened. Everything's okay. And that kind of contact goes a long way because it shows that you're thinking about this and you're prepared. The next thing that helps is if we do talk to you, if you do have the processes and the procedures in place. I've heard people, we're talking about doing tabletop exercises even before you have a data breach. You have some kind of plan in place. That's gonna help a lot if we do talk to you. Most of the people that we talk to, we find out what happened. It was a reasonable mistake. They had reasonable precautions. Something happened. We may just move on. We'll move on to the next target.
And I think Ryan can be brought in on this. I think I got the same call, and I suspect, Ryan, are you there, that you got the same call yesterday?
Yeah, absolutely. When companies contact us early on, that definitely gives us a lot of comfort. I think that the important thing to remember is, here in Vermont, we maybe get 2 or 3 data breach notices a day. That's hundreds a year. Obviously, we're not investigating and looking deeply into every one of these breaches. If a company is being investigated by an attorney general's office, something pretty bad probably happened. So it's not a matter of we're trying to victimize everybody who had a breach. It's, wow, what happened there? That's something that really is something we need to look at. We're really trying to look for the most egregious examples, basically to prevent other breaches from happening by showing other businesses that we take this seriously, and this is the sort of thing you should do. I also want to mention that in Vermont, we have a lot of small businesses here, which, as you probably well know, are a large source of breaches. More often than not, when we find out about a small business breach, we end up helping the business repair their security. We have experts here, forensic analysts who assist us, and we will often sit down with their IT people, go through what happened, and end up just assisting them in repairing the breaches. So, we both go after the really bad actors, but we also help the innocent victims who is just one of those things.
I think that's a good point, that the company that we're not mentioning is proactively reaching out to us, so we won't read about it in the newspaper. We won't hear about it from another state. We hear specific information. The company has come forward, and as Ryan said, it answers a lot of questions: who, what, when, where, and how. So we don't evolve or probably escalate into anything more. We understand what happened. It's been contained. They know about it. There probably aren't any next steps needed.
All your offices are, most of the attention goes to the investigations that you do, but much less attention to the services you provide to help companies avoid getting breached in the first place, or even helping them respond effectively. Ryan touched on what they do in Vermont to help companies respond effectively. Can you guys talk about what you do in Florida and California to do the same thing?
Basically, in Florida, we will get the call from the company saying they may not consider giving notice because they feel maybe under our statute it's sort of a gray area. And we'll walk them through that. In other cases where companies have not elected to do notice right away, here are some of the things where it may be problematic. If they say, well, we'll head toward notice, we don't know what kind of notice letter we should have, how much information should we have in it? And we always say details are important, the content's important. The more complete your notice letter is, and we'll walk them through that, the better it is later, the fewer questions consumers will have, the fewer misconceptions consumers will have as well. And probably we will get fewer calls in our office into our consumer complaint division about what happened. If the notice letter is complete, and that's something we do let them know, that we appreciate having that. We'll have it posted. We have it available. We can also say we can look at we can tell the consumer if they call and say, I just got a notice letter. Is this legitimate? We can say, actually, we have a copy of it. Yes, that is from the company. We can verify it's exactly what they sent out, and that's a comfort for consumers.
In California, we have a really great resource that we inherited from different agencies that similar to what's happening now, got defunded. A couple of years ago, the Office of Privacy Protection Joan McNabb, who I know a lot of you know about. And so we've taken a lot of the resources from the Office of Privacy Protection, and it's now on the office website at oag.ca.gov/privacy. Our focus is mainly on protecting consumers and educating consumers, but we also are interested in educating businesses. That's one of the reasons I'm here. We also do stuff like come out with the breach report that we did last year that surveyed the over 100 reportable data breaches that were reported to our website. Our website also has a very cool feature where a consumer or business can go onto the website and they can search and see who has reported if a greater than 500 data breach in California, so consumers can get educated about this. I highly recommend, if you haven't read this, it's a very good read. It gives you some good advice. Spoiler alert, there's a lot of talk about encryption.
Well, actually, let's use that as a segue, because one of the things that companies want to know is what types of incidents and what types of company conduct in the aftermath of an incident are most likely to spark your interest. And I know your office, Adam, has said that it's placing enforcement priority on unencrypted or the failure to use encryption. But generally speaking, how do you decide, and maybe we'll start with Ryan this time, how do you decide what breaches to investigate? As you said, Ryan, you've got more breach reports coming in than you have the resource to handle. So what are some of the factors that you look at in deciding when an incident is worth investigating?
Sure. I think that the first thing that we're going to look at is the letter to us where they notify. So we've got kind of a two-step process. We do the quick scan of the letter. If the date on the letter says that the breach happened 3 months ago and we're just now finding out about it, as you may know, in Vermont, we have mandatory reporting to the Attorney General within 14 days. So if they're clearly already in noncompliance when they send the letter, that's a really big red flag and will probably make us look a little bit deeper. Generally speaking, you have to describe what happened in the breach. And for the initial notice, that doesn't have to be an elaborate description. If it turns out to be wrong later, we don't really care about that. We just want to know that something happened. But if we get that kind of letter at 45 days of what's going out to the consumers, and the breach really looks fishy, if someone says, oops, we accidentally posted 100,000 social security numbers to the internet, then we may say, okay, we need to look at this. This isn't just kind of a run-of-the-mill thing. So that's how we kind of make the first cut situation. Here in Vermont, obviously, we're going to tend to look at Vermont businesses a little bit more closely. But in terms of what we decide is something that has legs that might need to actually require a full investigation, we actually just settled a case a few weeks ago with a small business here in Vermont, and the act that really caught them up was they discovered that the breach was happening, and they didn't take any action to stop it for a period of time that we thought was unacceptable. And during that time, a small data breach of maybe $5,000 worth of fraud grew into tens of thousands of dollars worth of fraud, which is a big deal here in Vermont. And we actually had instances where people were getting new credit cards issued by their banks, taking those credit cards to that business and having them stolen again, which is really kind of a worst-case scenario when you think about it. So there we're focusing not even on the security they had, but their behavior post-breach, which can be a big part of it. As far as what actual security we care about, the standard I've always thought is, we're not forensic experts here. If you report something and it's enough to send up a red flag in a lawyer who might not be an expert in forensics, that's pretty bad. That's the kind of low-hanging fruit that we're looking at this stage. In Vermont, we're not as concerned about the gray areas and is this on the line or isn't it. It's, wow, you really should have done something differently there.
Let me ask you guys the same question.
And I think the big point here is delay. Reasonable delay. Is it a situation where you didn't hire the forensic company until the delay was really long? Did the forensic company get on it right away and start to investigate? So when we have a phone call, whether it's just with Florida or a number of states, that you have a pretty good handle on the incident. You know whether it's been contained. You know whether there's anything left at the back door. You know also whether that you've really shut it down so it's not going to happen again. So I think a lot of that is basically how long did you wait to really investigate it? Did you wait until we called you, or did you call us first and say, here's the delay and it's reasonable, we've hired a company, it's very complex, it's going to take X amount of time, but we're here, this happened, and they're very proactive to let us know. That's much more helpful than finding out, as Ryan said, many months later, that a breach happened and we're just starting to look at it.
Yeah, arguably Vermont has a stricter standard than California. This 14 days that Ryan mentioned. In California, it's the most reasonable. It should be reasonable in the most expedient time possible. So I've observed situations where someone finds out about the breach, and then they have to spend time to do a forensics analysis, and they identify that certain numbers of consumers have been injured, but then they decide to wait for another 3 months until they finish the entire analysis, and we don't think that's reasonable. Some of the simple cases, kind of low-hanging fruit that I talked about, I can give you some specific examples of cases we filed. We sued Anthem a couple of years ago because they did a publishing of 30,000 Social Security numbers that you could read through a mirrored envelope, so people could see that, and that is a violation of a specific law that California has and many other states have. Another case we filed recently, a settlement against Citibank. You may remember about 2 years ago, Citibank Online suffered a massive breach where a hacker downloaded over 360,000 customer account information. And the reason why we decided to go after that was we viewed that as a very trivial exploit that was well known, well established. Those are the kinds of things we're going to go after. The other thing we're looking at a lot is unencrypted data at rest in laptops and USB drives. It's amazing how many times this happens, and that's the kind of thing where it's pretty straightforward to establish, and we think that's very serious.
I think to follow that up as well, it's the laptop, the employee who left it somewhere. It was unencrypted. There was no company education. There was no policy. Data at rest was no longer useful. It had been on the server. It had been on for many, many years, outlived its usefulness. They weren't even probably aware of it until the breach happened, and that's when they started to, take some action on it. And that's a tough situation to be in for a company.
I mean, one of the things that breach victims are often concerned about is reporting when they don't fully understand what it is they're reporting about, notifying consumers and then having to retract or correct what they've said to the consumer when they learn more about the incident, notifying the AG's office, and then having to correct or retract something because they don't have their hands around it yet. What is your recommendation about what a company should do? You've all said the early reporting is important and a key factor in your calculus. What if you don't yet know the full scope of the incident, either in terms of how many accounts were compromised? You may not even know which state's attorneys general you should be reporting to. What's your recommendation for how a company should handle that in the early stages?
Well, I think at the very least you might want to consider if at some point you realize that there is a significant data breach that's going to be reportable and you might just not know the scope, you might want to consider making contact with at least some AGs, for instance, the AG in your home state or an attorney general in a state that has a significant number of people. I think my feeling, although this is not necessarily reflected in California law, is as soon as you identify at least who some of the victims are, you need to start reporting. And you need to also have the processes in place in terms of the toll-free numbers and the letters. And then what I think needs to be done is kind of rolling production. As you identify more people, you have to keep on giving notices. I understand sometimes that's difficult. There may be mistakes made. But I think that consumers really would rather know early that they might have been a victim of theft of their personal information and then be told later, I'm sorry, actually, you're okay, rather than finding out about it 3 months later.
I think that's the company position that is sometimes tough to take from the response that we get, that they could do rolling notices, but make a complete set later instead of why should we alarm people before we know who everyone is. But the other issue would be if the consumer is out there and knows that somebody waited 6 months and they did have the right address or contact information and they chose not to notice them until they got everyone's name, that's a tougher position to defend.
And there's also provisions in California and other laws that provide for alternative notice. You can do publication. You can put a notice on your website. There's other ways that you can get the word out that there might be some information at risk.
Ryan, do you want to jump in there?
Yeah, I just want to say, in particular, the notice to the Attorney General's office. In Vermont, we statutorily protect the confidentiality of that notice, and as far as I can figure it, there's absolutely no downside to giving that notice. We literally look at that and say, okay, you've given us a heads up. We understand you don't have your arms around it yet. We may check back in 30 days or 45 days just to see if you're on top of it. But for the most part, all it does is says, you're on top of this. And it's also very helpful because then if we have had situations where we got the notice at 14 days and then there was some delay and it took them 60 days or 90 days to get the actual notice to consumers out, which is beyond our 45-day limit, and we'll say, okay, well, they did notice us, so clearly they were on top of this, and we're much more likely to believe them that their delay was legitimate than if we're first hearing about them, all that time later.
So I have to distinguish slightly between Vermont law and California law. In California law, the copy of the notice that you submit to the Attorney General is public record because it's just simply a form notice that you might send out. However, if you were to make a phone call, that would not be necessarily public. So if you did have some early indication that you have something coming and you're not sure how long it's going to take you to assess, then contacting, say, my office early might help.
Actually, let me clarify that. There are two notices, really. In Vermont, the 14-day notice is where you just give the AG a heads up. We also like to see the notice that comes in maybe 40 days later when it's going out to the customers, and we do post that to our website. And we have a provision that says you can give us a redacted copy, and we'll post that to our website. But I was talking about that initial, when you really don't know what's going on necessarily. That's confidential. We're not going to issue a press release or anything about that.
And one quick thing on public notice. Anything that would further disseminate the breach is something that you really want to be careful about, because sometimes when companies are trying to be helpful, there may be personal information there that once we take receipt of, we have it, and we don't want to have to deal with that issue of in any way disseminating more of that private information because we're looking at it.
Besides early notification to your offices, what other factors sort of weigh into the preliminary calculus about whether you're going to pursue an investigation? For example, if you look at the number of victims, the estimated dollar loss, if it's a company in an industry where a lot of their competitors have already been breached, what are some other factors that you look at?
Well, I think certainly in California, the number of victims is going to be significant. We just don't have the resources. I mean, we had in California over 112, I think, data breach notifications in 2012. We can't, even if we wanted to, we couldn't go after all of those. So we're certainly going to focus on the ones where there are large numbers of victims in place. And then again, a lot of the stuff that I've heard today about having a good plan in place, having a chief privacy officer, even if you don't have a CPO, at least having someone that's in charge that you can say this is the person that's responsible for privacy, even if they don't have a title of CPO. That helps.
I think so too. I think when I first started to get breach reports from companies, and or from maybe a newspaper article, or maybe we would get consumer complaints, which is an answer to your question. It could be consumers are starting to complain to us. They heard about it in another state. They read an article. The size of the breach obviously is important to us. But I think many times now companies are getting better at having somebody designated, so when we call, we're not going through the switchboard operator and kind of trying to find somebody who may know something about the data breach. So it is important that you have somebody who we can contact who knows that the 800 number that we're going to give out to consumers works, that knows if credit monitoring is being offered, how's that happening, just the basics on the ground. They seem very simple, but a lot of times those things are what happen with consumers that they'll call us and say, oh, now the company doesn't even have an 800 number. Where do we go for help? So things like that, a good response team is very helpful to us.
Ryan, how about you?
I think a lot of them have been said already. I mean, objectively, we tend to look at local impact, number of affected consumers, if we're getting complaints. Certainly if we get a complaint about something that we didn't know about because they had to report to us, seriousness of the violation, type of breach. And then because of our limited resources, we're going to look at the deterrence or strategic value of going after a specific type of breach. If it's a type of behavior where we say, frankly, this is an example that needs to be made. We have had cases where there are breaches where the banking community is saying, this breach is going on. Is someone going to do something about this? This is really bad. And I think the last factor, and a big one, is kind of the kind of culpability or the attitude of the breach victim when you finally do communicate with them. If they seem to be of the attitude of, okay, something went wrong, we want to protect our consumers, we want to do everything right, what do we have to do? That's going to go a long more way than the company that says, look, I'm the victim. This is going to cost me too much money. Why should I have to do this? I just, need to do the bare minimum to comply with the law and get on with this. Because, like I said, we're making kind of a quick decision, and and so we're going to go after the guys who we think, we need to target.
I think one other issue that we can encounter, and they mentioned it today about how many third parties are now involved in these issues. And when the delay of notice is because the company doesn't know or doesn't agree with whomever maintains the database, because that's who should be issuing notice. So if they're in a struggle with a third-party vendor, that's usually not helpful because somebody's going to have to make that call. We can't make that call. And there have been times when they've said, who do you think is maintaining the database? Well, we don't have all the facts of how your company is run and who truly has the control or is maintaining it. So that struggle of who sends out notice is usually better off resolved early because the clock is ticking on when the notice goes out.
You've all alluded to the fact that a company, the way a company comports itself in the aftermath of a breach, demonstrating that it's taking the matter seriously is a factor in your calculus. I can tell you that one of the things that I found most challenging in talking to companies about breach preparedness is trying to persuade them to take proactive measures to put themselves in the best possible position if they are breached, because a lot of companies don't want to spend money to solve a problem they don't believe they've experienced yet. Talk to us a little more. You mentioned tabletops, and Adam mentioned having a person in charge, whether that person has a CPO title or not. What are some other proactive steps that a company could take before they're breached that, if the worst happens and they are breached, would make that company be in the best possible standing as you evaluate their conduct?
Well, I think, from what I've heard today, thinking about the possibility of breach before rather than after, it's certainly difficult. Protecting against breaches is not, I guess, the typical core business for a lot of the companies that you might insure or may represent. But I kind of view PII as kind of a toxic chemical. It can be very useful in doing good things, but you have to be careful because it gets out, it's going to do damage. And from my perspective, even if that damage is actually not harming a consumer in terms of resulting in credit loss or actual monetary loss, from a regulated standpoint, we don't have the standing issues in California that a consumer might have, where class action might be dismissed because of lack of standing. Under our unfair competition law, it's essentially kind of a strict liability. If you violated a breach law, notification law, if you violated the safeguards law, if we don't think you've taken reasonable safeguards and we can prove it, then we have an unfair competition law action against you, which is $2,500 per violation. And I certainly agree with several of the commentators previously that each record is a separate violation. And I also agree with the opinion that I think the class action panel said, that arguably it's every time that piece of information is exchanged back and forth that's a separate violation. Now, it's true that there aren't I'm not sure of any court decisions that have actually said that, but certainly that's our position, that every time that piece of information, the sensitive personal information is exposed, that's another violation under California law.
I think another issue is that when consumers don't think that we have been contacted and that the state is involved at all, is becoming more problematic. And I think from when I first started to get breach notices till now, I think the consumers are getting more sophisticated. They want to know that we're aware of it. What are we doing about it? Have we contacted the company? But another issue that's changing as far as what I'm seeing is that consumers now want to know point of breach. Before, they just knew that their data was breached. Now they're getting much more active in, if they get a notice letter that doesn't say where the breach was, pushing more to find out, I may not want to shop there anymore. I may not want to buy gas there anymore. So I notice that, I guess that's more of an education issue with consumers, more sophisticated on these issues, and obviously probably because there's been so much attention and more awareness.
Ryan, what are some of the things that a company can do proactively, in your view, that would communicate to you its seriousness about this and that it was trying to be good stewards of personal information?
Well, I mean, definitely, again, it really just comes back down to, when we hear from them, how quickly we hear from them. And actually, let me give you a really good example, probably the best example. There was a data breach in late 2012, early 2013 in a chain of bagel bakeries in Vermont and New Hampshire and Maine. And basically what happened was they discovered the breach on a Thursday. On Friday, they contacted Secret Service, pulled the hard drives from every computer, except for one store which the Secret Service was using to set up a sting and try to catch the guys. And then the following Monday, I got a call from the president of the organization explaining exactly what happened, what they had done, what they were doing. We talked for half an hour, 45 minutes. And, basically at the end of that, I said, hey, looks good. Looks like you guys have it covered. I called back maybe 2 months later just to see how things were going. And, once I found out about, how the breach happened, I thought to myself, okay, well, there may have been some other factors from outside vendors that maybe we might even want to look at now. And, so that was probably the best case scenario, how you can handle a breach. And it showed they were completely on top of it, straight talkers, and, we didn't even have any desire to investigate any further.
You mentioned, Adam, tabletops and having an incident response plan in place as being a factor in demonstrating that a company was taking the risk of a breach seriously. How important in your calculus, if at all, is the fact that the company has cybersecurity insurance?
Until about a year ago, I didn't even know that cybersecurity insurance existed. Right now, it's not really a factor. It's not like in slip and fall or automobile litigation where you have a case and there's insurance and you can sue for up to limits of coverage. We don't typically ask a target, oh, by the way, do you have insurance? My attitude towards cyber insurance, especially after hearing some of the very helpful presentations today, is to the extent that cyber insurance acts as kind of a quasi-regulator, because it's teaching the company what steps they need to take, what education, what training, what policies, the actual exercises they have to go. That's very helpful to us. It basically makes our job a lot easier. However, to the extent you just give an insurance policy to anybody without doing due diligence and adequate underwriting, and you're essentially just insuring a leaky roof, that's not going to be very helpful.
I think that's a good answer. I think it increases awareness. It brings up compliance issues. It measures vulnerabilities, in terms of things that we probably will be asking specifically when we do an incident report and talk to them. And a company that has those answers prepared, that they don't start thinking about a breach the day it happens, is much more helpful. And I think that goes toward being prepared.
Ryan, do you want to?
I would just add that I think it's great. I think because a breach is really often a one-time sort of thing. So it's not the sort of thing that really makes sense to devote resources towards thinking too heavily about this thing if you can outsource it, like you think of all the other disasters that might happen where insurance is the case. And I don't know what the policies are out there, but I'm really hoping that someone is designing a policy for small businesses that's affordable, because small businesses, the bottom line, they're often just trying to stay open. And if there was something out there that would really bring up the level of small businesses, I think that would be very helpful, not just to the businesses and to our offices, but to consumers generally, because it'll make them take security more seriously.
Yeah, my own hope is that the availability of insurance will change the economic incentives of companies to actually take proactive measures. That in order to get coverage or to get coverage at a lower rate, it creates an economic incentive for companies to take the kind of measures that you're talking about. You've all handled probably more breaches than you can count, and you've seen companies that handled them really, really well, and you've probably seen companies that handled them not as well. So it's war story time. Tell us, changing the names, leaving the names out, using the names, whatever you want. If you could give us some examples that you think will give us takeaways of what to do and what not to do in responding to a breach.
I would say I hear from a company, and there are a lot of moving pieces in a breach, and I think of somebody with a lot of yellow sticky notes, that the person on the other end has not had a good day, probably hasn't had a good few days. And what I hear in some of the things that have happened with me is I can always tell when a company is just getting started in analyzing their security system. And they evolve. By the end of the breach, by the end of the time that we have talked to them, they they won't be the same on the second breach, but you can tell when it's the first time. They have not put any systems in place. They don't know sometimes maybe what data at rest is. They hadn't thought about encryption. They thought the cost of certain security measures was too high. They didn't realize that the cost of giving notice, of getting forensic experts, was really going to be even more significant. So those cost-saving measures, in the end, weren't that helpful for them. So without any specific war story, I think the conglomerate is awareness, and you can usually tell from, I think, our perspective, what companies have systems in place and which ones are just starting to think about it at a crisis moment.
Well, I don't have a lot of war stories because I've only been doing this for a short amount of time, but from what I've understood, the kinds of bad situations, on the one hand, I've talked about, and we've all talked about trying to do reporting and notification in the most expedient time possible. The flip side is you don't want to rush too quickly. So I've heard stories where someone has put out a notice with a telephone number and the telephone number doesn't work. Another issue is notices that are too complicated to read. There was, I think, a bill that was proposed that wasn't passed to require that privacy policies, it's not data breach issues, privacy policies should be limited to a certain number of 100 words or less. For data breach notices, I think in the data breach report, I think some of the average levels calculated were like 14th grade, college level. So you have to make these things simple. California law actually says it has to be in plain language. And again, I want to emphasize the role in notification. As soon as you know enough about the breach, you really should start thinking, if I'm a consumer, would I like to know about this sooner rather than waiting until I identify everybody and I dot all my I's and cross all my T's?
Ryan, war stories?
Well, two have already been mentioned. There was the company that didn't do anything to protect their data and let it get out of control. And another one Patrice mentioned, or a similar situation of a company that was a vendor to thousands of businesses, and when the breach happened, said, oh, well, we don't own or license the data, so you, our clients, have to send out individual notices. So instead of the one company that actually suffered the breach, they were trying to get their thousands of clients to all lawyer up and, get their own people to do the notice. And they tried going down that path for a while until I think they got a lot of pushback from a lot of places and backed down, although they still insisted they didn't own or license the data and for whatever reason. I would just say that, sometimes there'll be a breach, a nationwide breach or a large regional breach, and the lawyers and the IT folks will get on the phone with a lot of us AAGs in many different states, and they do, kind of the big talk, here's what happened and whatever. And, and I've seen those go, very differently. There's the case where they're really just very straightforward and say, here's what happened, and, we want to cooperate and we want to do everything. And then there are the cases where they're clearly defensive. You say, well, we kind of want to look at some of the forensics and understand it well. We're not going to give you that. And when they get really, especially given that if the company really didn't do that much wrong, usually they're willing to tell us everything. So if they aren't willing to tell us everything, if they're being really defensive, that really tends to put up our antennas and say, oh, well, now we know who we have to, really drill in deeper to. And then the second thing, I don't know if this is a horrible practice, it's more of a pet peeve, is sometimes you'll get on the call and, the other side has to start with this long speech about, let's tell you all of our security, how great we are, everything we did, we're a great company, we give to charity, we've gotten these awards, and that takes about 20 minutes, and you're thinking like, well, okay, what happened? And, obviously your security was great, but you still had a breach, so most of what you just told us is kind of irrelevant. So that kind of, snow job sort of thing is something that I think just kind of irritates folks.
And Brian's right. A lot of times we all are on the same call. It'll be Company X, and we've all gotten the call, and then we decided it's much more efficient to have a call across the country than do it piecemeal where the company is going through this forensic exercise with us on each phone call, so we'll have one call with many states. And sometimes the defensiveness, you wonder if it's part of a poor data security system, so there's a certain defensiveness. And on the other hand, it could just be the pressure for an immediate response to a very serious situation. I think most companies agree that once they realize the severity of a data breach and all that it could entail, not in terms just of PR and the harm to consumers, but the harm to their internal structure, to their product, the compromise, the exposure, these it is never a good day for a company. And that's why we feel when we have these calls, the more that you can tell us, even though I know there is a feeling if we don't have a complete incident report, we're going to wait. It's probably better just to let us know what you do know for sure. I think it's better to be proactive, as we said a lot today.
How often, you mentioned a couple of times that you all will have calls among different states to share information about breaches. How often do you have those calls? Are they a regular thing, or are they case-specific? And how often do you coordinate your investigative work on major breaches with your colleagues in other states?
So we have regular scheduled calls, that we talk about different cases. And then if we have specific cases, we might have more targeted calls. But we're all on email and phone, and we talk a lot amongst ourselves. We talk occasionally to the FTC. We definitely try to keep each other informed.
Do you, we mentioned a bunch of different things that go into your calculus about how do you deploy your investigative resources, and you just mentioned the FTC, which is obviously very, very active in this space. As part of your decision about how to deploy your resources, which cases to investigate, which cases not to, do you look at what the FTC is doing, and does that have any role in your decision about which cases to pursue?
I think generally aware of what the FTC is doing, but I think I would say a data breach is like a fingerprint. No two are alike. They are fact-specific. So I don't think I have a magic formula for when the FTC is part of our thinking and when it's not. But obviously we're aware of what they're doing. And there's no sense to really duplicate if that's possible not to do that.
One of the reasons we have these regularly scheduled calls, both in privacy and other areas, is we routinely have multi-state investigations where there's a data breach or an antitrust violation or a consumer protection concern, and a bunch of significant states, Florida, Vermont, New York, Texas, California, will get together and say, hey, let's talk about this. Let's figure out, can we do this together? We're trying to get the biggest bang for our buck.
And sometimes they are incident reviews. What happened here? We heard about it. We're at the very basic level of who, what, when, where, and how. Other times they may escalate into a full-scale multi-state case, such as TJX a few years back, and it did escalate. And many states were involved in that, and there was a final settlement with that. But it goes anywhere from just a phone call with a company to it could be a full-scale case.
Now we've been breached, so let's talk about notification. We just marked the 10-year anniversary of California's breach notification law. I'm sure all of you celebrated it as I did. There are now breach notification laws in 46 states, plus D.C., Puerto Rico.
You're welcome.
Guam and the Virgin Islands. And Congress has been considering a federal breach notification law that I helped write, one of several cyber-related proposals I helped write that Congress didn't act on. Just last week, Ryan's boss predicted that there's no way we'd see a federal breach notification law passed. That may be because the government shut down. It may be because they can't agree on anything. But I think you all would recognize that the patchwork of laws makes compliance more challenging for companies than if there was one uniform standard. Two of your states, Vermont and California, recently made changes to your data breach notification laws. So first I want to ask Ryan and Adam to talk a little bit about the recent changes to and the significance of those changes to your state laws, and then give each of you a chance to weigh in, again, giving your personal views on the benefits and drawbacks of having one uniform federal standard versus the patchwork that we have now.
Well, we tried to just make one standard, but everybody copied us. So in California, we've done a couple of new changes, and I have a couple of that are not data breach. I thought I would just talk about them all. So AB 370 amends the California Online Privacy Protection Act to add that you have to notify consumers how you deal with signal tracking or do not track signals coming from browsers. ABA 658 modifies the California Medical Information Act to any business that offers medical apps. Most important to this group, SB 46 amends our data breach law to require notification of breaches involving just user ID and password, and you can give notice to people using their account information. But if it's a user ID and a password for an email account, there are alternate ways to do it, including doing a pop-up to an IP address that person has done, or other substitute forms of notice. AB 1149 imposes requirements of data breach notification law to local government agencies. And I heard someone talk about this as well. AB 568 adds this new digital privacy rights for minors, this so-called eraser bill. That's not effective until January 2015. In terms of the national data breach law, I certainly feel the pain of people in this room and counsel and companies that have to deal with 46 different states, and also if they're in the EU or other foreign jurisdictions. But at least for the United States, this is our system of federalism, and especially in a time like today, where the federal government just doesn't seem to be able to work. It's been said that the states are the laboratories of democracy, and this is a really good example. That California is trying to lead by being innovative and trying to do things to protect consumers, and we must be doing something right because we're getting copied a lot. I would have no objection, personally, in my personal view, to a federal data breach law, so long as it was not the lowest common denominator of the data breach laws that are out there. So, of course, I'd want it to be identical or better than California. And more importantly, it would have to permit parallel enforcement. It could not work if the feds just come in and said, you know what, this is interstate commerce, we preempt everything else, we're going to take this over, and only we can enforce it. Because what would happen in a time like today when the government has shut down? And quite frankly, I think this is going to happen again in the future. That's my 2 cents.
Ryan, how about the changes to Vermont's law that went into effect this summer?
Sure. The changes to the Vermont law were not enormous. Well, I suppose they might be for the insurance industry. Basically, we have the Attorney General has certain reporting to us, and then anyone who's regulated by our Department of Financial Regulation, which includes banks, insurance, financial companies, they now have to mandatorily report to DFR. So that's really the big change. It just kind of brings the DFR back up in parallel with our statute. I would say I pretty much agree with everything Adam said. I think that a federal standard would probably be best. Having seen how this legislation goes through, it's actually kind of ironic because, what happens is we start off with a statute that looks very much like California's, and then, a bunch of different stakeholders come in and say, oh, well, we want to tweak it here. Oh, well, our constituents want something different here. And, next thing you know, they're complaining that it looks different than California's. So that's just kind of how that happens. But I also agree about there needs to be parallel ability to prosecute these things with the states. For my concern, the reason is because there's a lot of stuff we do here in Vermont that I am sure the FTC would have no interest in pursuing. They're going to cherry pick the specific cases and national cases that they want to pursue. But, the guy down the street who's been having a data breach and letting it go, that's going to just fly right under their radar. And I definitely would be in favor of more coordination of how the data breach happens. And I do feel for the businesses that have to deal with all these different state laws, and I hope that someday it's going to happen. Of course, the government has to open up before they're going to actually, do anything. So we'll see.
I agree basically about my opinion only is parallel enforcement, because it would be a daunting task to have any agency try to enforce and look after all of these data breaches across the country. Having said that, I've heard from so many companies saying how unmanageable it is to try to respond to 45 different breach statutes. 46. And it is a problem. I understand that. But the parallel enforcement would be important if we went that way.
Oh, and one other issue is that in addition to parallel enforcement, I've heard of proposals that would say that any of these statutes would have to be enforced in federal court. And I would say that for reasons of federalism, we enforce all of our Consumer Protection Act statutes in state court. Most of these guys who are doing data breach, not in California, but in most other states, are also consumer protection lawyers. And I think that our state courts are more than capable of handling these cases.
A couple other questions, and then we'll turn it over to the audience. We focused a lot on the factors that might cause someone to get investigated when they get breached, and we've talked a little bit about the resources your offices have available to help companies respond effectively. Let's talk a little bit about what your offices do to educate companies about their cybersecurity risks. Ryan, I know in Vermont they have a cyber boot camp and some other programs for companies in Vermont to learn about and defend against cybersecurity risks. Do you want to talk about those?
Sure. I mean, we have done panels throughout the state. Yesterday I was actually just at Middlesex College. That's why I couldn't be there today, for a full-day session in which we had several speakers. The Attorney General spoke. We've done webinars. anyone in the state, various people in the audience have picked up the phone and called me just to ask for clarification on our law. We normally have a policy that we don't give out legal advice. We tell people to talk to their lawyers. We kind of make an exception in the data breach area because it is a confusing area of law, and if people get it wrong, it's going to cause a huge amount of burden to consumers and us and themselves. So we do a lot of education throughout the state. We even created a program called Scan Vermont, in which the folks at Norwich University were offering to do penetration testing to any small business that wanted it for $100. And we had a caveat in there that if they caught anything, they'd have to fix it. So no one's actually taken us up on that offer yet. So, we've tried to be very, very innovative in the state, and we happen to have at Champlain College and Norwich University two of the top forensics programs in the country, and the folks there help out our office all the time. So we've definitely been reaching out all over the place to try to educate.
One thing else I will say, and we sometimes mention this among ourselves, is that this is a fast-evolving area, and when people say they've been experts in this area for 20 years, we know that's not possible because you may have been an expert even a year ago, and the knowledge is moving so quickly. So bottom line, we look toward consumer education as something we're very interested in, and I think on the part of companies becoming more aware and becoming more educated on all of the things that could happen, all of the pitfalls. So a lot of what we see is consumer education is going to go a long way in this area on all sides.
And I'll make another plug for the oag.ca.gov privacy website and also oag.ca.gov ID theft, which has really good resources for consumers if you're a victim of ID theft, checklists, forms, very useful information.
Okay, let's open it up to all of you if anyone has questions other than where's the bar?
Or who's buying.
Where's mine?
So you put the bar in your mind.
Right, that's right.
Any questions?
Oh, excellent.
We have a question. Is this thing on? On one? You will see when I get there.
So one question, when you're talking about the factors about whether or not you'd investigate a company that reports a breach, you didn't mention the type of data that was involved. Is that something that you guys consider?
Yes. Certainly we have a concern about Social Security numbers, financial data, medical records. The states have. By the way, I agree with Ryan about the a federal data breach law. That my preference would be to permit state law enforcement, but we do have several laws that do permit parallel enforcement, such as Children's Online Privacy Protection Act and HIPAA. So HIPAA is a good example also in that not only can we use HIPAA and high-tech to enforce data breaches or other medical privacy violations, but we also have the California Medical Information Act that came out before HIPAA. And what's nice about how HIPAA works is HIPAA is a floor. And so HIPAA specifically says that if you have privacy laws that's stricter than that, then the stricter law applies. So certainly medical information is something we're very concerned with.
But it's a good question because sometimes companies will call and they'll volunteer that there's been some type of breach and the information is very basic. It's not PII, personal identifying information. It's not a social security number. So something like that. So the nature of the information is a very important consideration.
And I would just add that I think credit card breaches are probably far more ubiquitous than other kinds of breaches. I'm not sure I've dealt with one where someone lost people's financial account information or financial password information. For one thing, we actually have an exemption in the AGs from notice requirements by the banks, so that's not as big an issue. So I would say if it's Social Security numbers, that can be more sensitive because the first question is going to be, well, why were you collecting Social Security numbers? Did you have to collect them? Were you disposing of them properly? Were you using them in a way that, some other kind of ID number would have made more sense? At this stage, I think a lot of businesses are much smarter about using Social Security numbers, but you still find those outstanding cases.